Okay, so we will start with an overview of what is algorithmic bias, but it will be very, very high level. Then we will be looking at the, then we'll be looking at the sources of bias, so where bias comes from. Then we will be looking at fairness at the intersection between non-discrimination and privacy law. Then we will be looking at the limits within non-discrimination law as it is at the moment. And then we will be looking into liability legislation and the two proposals that are there, because this is a little bit where we need a bit of help, and I would like to see your involvement in what is happening on liability, as well as from you, John. And then we'll be looking at conclusions, next steps, and areas of research. So we've seen all this, right? So we have seen how AI can discriminate, how algorithmic discrimination has real harms that impact on the livelihood of people. This is something that we've been looking at for many, many years, particularly in the US, where data scientists and engineers, especially women of color, have been looking into this for decades. One recent study from the UNESCO, which was published just a few days ago, is very clear in showing how bias is coded into LLMs and generative AI. How it's done it in a very overt way, not particularly clear, but how racial discrimination in particular emerges from generative AI. And I remember at the beginning when generative AI made a splash, when ChatGPT made a splash last year, I remember asking ChatGPT a question, and the question was very simple, was that, tell me a story about a boy and a girl who want to go to university, and they are best friends, and they're deciding what to do when they grow up. And ChatGPT responded and said, once upon a time, there was a boy and a girl. The boy decided to do engineering. The girl decided to study art because she said, I don't know anything about numbers. So, and this was at the very beginning. And to be fair, we as women leading in AI, but also as working with the network of academics in the US, we have worked alongside OpenAI to try and look at the answers, and there's been a lot of efforts being made. Nevertheless, the UNESCO report is quite clear on how these sort of generative AI tools, and so I'm not talking about the sort of more traditional AI like machine learning, I'm talking about generative AI, so AI that creates, how these tools code and softwareize these stereotypes into this creation and generation of text or answers. So we have seen all of this. So what is algorithmic bias? So there is a definition that we put in the report and it's been approved unanimously by the Council of Europe discussions on this, which is when sort of seemingly innocuous programming takes on the prejudices either of its creators or the data that is fed. So I recommend everyone Sophia Noble in a concept of algorithmic oppression. Bias is not a glitch in an unbiased system, but is instead systemic and inherent in the functioning of information systems powering search engines and other web applications. Now, there's one point that I want to start making today, and this relates to the debiasing stuff that people were mentioning earlier. Okay, fairness, as it comes clear from here, fairness is a social issue, right? Algorithmic fairness, right, is very different from social justice. It's definitely different from societal justice. And the other point I wanted to make, and there is no such thing as a debiasing tool in the world, and there will never be. And it's important to understand this, in my view, because of fairness being a social problem, right? Because of an AI tool being a social technical tool, any artifact that wants to be non-biased is an artifact where the developers have made a social political choice for that tool not to be biased. So if I deal with debiasing technologies, and I'm part of an organization that uses the biotechnology. I use them as a support tool. If anything, I use it as a support tool to possibly identify bias that I haven't seen, and correlation between things that lead to bias which I haven't thought about before. But this is not about debiasing. So let's be very, very clear about this, and also let's be clear there is no such thing about a technical tool that can address a political and social issue. And I'm talking as somebody who is very much into technology. I code. I am an intersection between law and technology, but I always say to all the data scientists, all the engineers I work with, this is a social problem. So if we as a company, we make a decision to be unbiased, and I don't like the word bias that much, but we make a decision that we want to recruit 50-50, that we want to avoid bias, we make a social political decision to do so. And then we mathematically work out how to do it from a technical standpoint. But the decision, to be fair, comes at the very beginning of the process. And this is where the alignment between different people needs to come. And then we'll come to that in a second. But I really wanted to make this point because I heard auditing of bias, and every time I see auditing of bias, I freeze. Because this is where, to me, the techno-solutionist approach of the recent years has come from. You know, is really confusing a social problem with a technological one, and it's not right. It's not right for the technologists. It's not right for computer scientists, and it's not right for people, lawyers. It's not right for society. There are two sets of issues. So please let's focus on this. There is, and again, I'm going to repeat it very clearly. There is a big difference between algorithmic fairness and social justice. They're not the same thing at all. Okay? And the second thing is, bias is a social problem and a political one. This is because of how society is, and therefore, unbiasing, debiasing an AI system is not a purely technological issue. It's a social one and requires a social and a political decision to be unbiased. So where does bias come from? Many, many different things. You have seen this many times. I just wanted to say, because people say it comes from the data, and again I say, yes, okay, it comes from the data, garbage in, garbage out, we know that, but it doesn't only come from the data. And also, surprise, surprise, as you all know, you can have the most technically debiased system and yet have a biased outcome. I'll tell you an example, facial recognition. If I have a facial recognition system that does not make mistake with people of color, and especially black women, and yet I deploy that system in poorer areas of a city, I will get a biased output. So again, let's not get confused between different domains, you know, a domain of a social problem and a domain of a technical one. Okay, so bias comes from all these different areas, and as I mean, we know Cathy O'Neill, that an algorithm has an opinion in a code, and we know also that an algorithm is basically a bundle of data parameters and people, none of these be neutral. That means that it's very difficult to make something that is neutral, which it just shouldn't even be. So just bear that in mind and understand that I work through with, in my company, we work it through with my technical teams, data scientists, with the lawyers, with the change managers, and I put this up and we go into the details of every single bit of it, and I explain what that means. And when I get the lawyers, so people come from change management of HR, they come and say, well, we don't understand AI. I'm not talking about AI, I'm talking about historical bias. Then then we can understand how it applies to AI and statistics. But I am here talking about parameters. I'm talking about the fact that if I train an algorithm in an area of the country and it latches is onto local data there and then I use it somewhere else, then that algorithm will obviously be biased. So it's really about using the right language and simplifying the concept to make people understand that because every AI artifact is social-technical, then there is a lot of social that needs to be understood by the technical people, and a lot of technical that needs to be understood by the non-social ones, the non-technical ones. So what are the challenges? So there's a lot of text, but also because I wanted you to have this presentation, so I put a lot of, it's like I want you to see it as a summary of the report that we did for the Council of Europe, so you don't have to read the whole thing. You can just look at the summary. So, I mean, we have seen a lot of the challenges have been emerging over recent times. So, of course, what is the issue with bias? The issue with algorithmic bias is that how it scales up, because it's used more and more and a lot in ways that we don't even know. And it's very difficult to identify and address because people don't understand that it's happening. Sometimes we don't know. Sometimes it's very subtle. And then the issues that was mentioned before around proxies, and I will come to that in a bit of detail. And then of course the fact that these AI systems are often non-transparent. I mean, some systems are very transparent. Some algorithms that I work with are very transparent. Some of them, once they enter into the black box stage, they're much more difficult to understand. The clash with IP and copyright, and also what we said at the beginning. So the political decision that needs to go with it. So this is why understanding algorithmic bias is, in my view, quite complicated. And this is why I'm looking forward to your work, and I want to be in touch with every one of you moving forward with the Council of Europe or with the areas of research that we're looking into, because it requires an approach that brings together different disciplines, such as social science, ethics, the law, regulatory field, legislation on non-discrimination, consumer protection, data protection, and trade legislation. So this is the kind of people that we need to come together when it comes to tackling algorithmic discrimination. So I just wanted for a second to focus on what it means for an algorithm to be fair. Okay, because I've heard the sentence, fairness means different things to different people. Yeah, so let's look into this concept of fairness quite in a bit of detail. So if I look at privacy law, and privacy law, my background is privacy law. So privacy law has, and I am actually, I'll shock you, Sarah, I'm a fan of GDPR, but no, I won't go that far. But I will say that I am very strongly convinced that data privacy plays a big role when it comes to uphold individual rights and fairness in the age of algorithmic discrimination. And I'll tell you why. First, because fairness in privacy law sits at the intersection between two concepts. One is transparency and one is lawfulness. So when you look at fairness from a privacy law standpoint, you think about these two concepts. Lawfulness, you must have a reason for this data to be there, to be collected. And transparency, which is the fact that there has to be a degree of meaningful transparency in processing this data. There is fairness in processing, which is basically, in a nutshell, that if I find out how my data is processed, it should be in line with what I expect from an organization to process this data. That is, in a nutshell, the idea of fairness. I'm okay with it because I would expect it. Okay, it's fair. But there is also fairness in the outputs from a privacy standpoint. There is a complex topic around accuracy in privacy that we are trying to navigate. How you navigate accuracy, statistical accuracy, accuracy of the data, where sometimes you do need to manipulate the data in order to have a fair output. Okay? And another conflict that you may have in privacy law is, this data is sensitive, special category of data, I can't collect it. Actually, you can. And there is nowhere the privacy law stops you from collecting special categories of data to test an algorithm for fairness. and I'd be taking on anyone who says that there is, because there is a legal obligation not to discriminate, which supersedes any other grounds in GDPR. And this shows why data protection authorities have been quite successful in upholding people's rights in algorithmic decision making over the last few years. There is a fantastic report done by the Future Privacy Forum, which really looks into, and I'm sorry, should I put the link? Just remind me. But if you Google it, Future Privacy Forum, algorithmic decision making, but really shows how the concept of fairness in processing, fairness in outputs, accuracy, statistical accuracy, has been leveraged by data protection authorities to protect individuals. So for example, the Italian regulator has said very clearly an algorithm decision is not fair because it's not transparent. The concept also said something like, which is like in itself is very crazy then to translate into practice, but think about this, the Italian regulator in a specific matter, I think it was about a Spanish delivery company. The Italian regulator said the consent is not meaningful because the algorithm was not transparent. I mean, a sentence which is crazy in itself, but it shows the attempt from a privacy standpoint, and we can't underestimate privacy in this. And then you have obviously non-discrimination law, where we'll be looking at targeting those who have been, so the non-discrimination law, which will be limited to those targeting or otherwise impacting in a negative way protected groups. And then obviously computer scientists have developed over the last few years a huge amount of methodologies and definitions for fairness. And as you know, the problem with these definitions for fairness is that they contradict each other. They do not work together. So you can have a situation where, depending on the definition that you choose from a computational standpoint, the algorithm may be technically fair and yet not be compliant from an anti-discrimination law. And then we mentioned the limits on auditing, and then again I make this point over and over again, bias and fairness are technical notions that do not overlap with their ethical and legal counterparts. So where does algorithmic discrimination fall into the crack? And this was a little bit what we tried to address at the Council of Europe, when we basically said, hey, look, we've got to look at the law because it's not working like this. So first of all is the lack of a neat overlap between existing concepts of direct and indirect discrimination and forms of algorithmic discrimination. Then, because of procedural issues linked to evidence and responsibilities, and then challenges linked to the concept of protected characteristics in the law. And I've realized what time it is. Sorry, because I might just can go for hours, and then it's my favorite topic in the world, so and I will write this report, so I could just go on.
20 minutes.
20?
Yeah.
Okay. So far, and tell me if I'm wrong. Please interrupt me, yeah? I mean, if you want to say something, interrupt me. I should have said it, but so we think that indirect discrimination would be what is more applicable in the context of algorithmic discrimination. And that's because, so do you know what indirect discrimination is? And which is captures situations where formally neutral measures produce a disadvantage because they intervene in an unequal sort of social context. And to an extent, this is what is more likely to apply to algorithmic discrimination, because sort of these data-driven technologies incorporate and perpetuate societies and equal status quo. So indirect discrimination, as we've seen so far, focuses on the structural dimensions of discrimination. And this works well when it comes to machine learning, because machine learning produces patterns, and so it seems to be a very good fit for indirect discrimination. Seems to be a very good fit. And also because indirect discrimination seems to fit quite well with the concept of proxies. And the concept of proxies is something that you're familiar with, which is probably the biggest challenge when it comes to algorithmic discrimination. So Raphael and I wrote this report. We looked at the concept of proxies. We looked at the feedback loops that you know, and sort of what is happening in terms of perpetuating existing stereotypes through sort of feedback loops, and what is happening, for example, in social media and this kind of areas. And we looked at the fact that the main problem that we're facing is this lack of overlap between the traditional grounds of discrimination. So whereby you may be discriminated because of the color, just because of race. You may be discriminated, I work for an Indian company, you may be discriminated because of caste, or you may be for another reason. But this is not in line with what is happening with algorithmic discrimination, where yes, the discrimination happens by proxy, but also algorithmic discrimination, AI algorithms create new groups. They may not overlap with the traditional discrimination categories. So what we have seen in online shops, for example, is an example that I put in here, which is an online shop may find that consumers that use a particular web browser pay less attention to prices, and the store can charge those customers extra. So this group does not correspond to any specific protected characteristic. Although it may, in another way, but not so clearly, but it may also create another group or another source of discrimination, and that gets embedded into and consolidate into emergent structural discrimination. So this is a problem that we need to face, this lack of overlap. Because to an extent, with all the issues of transparencies, with all the issue of when it comes to indirect discrimination based on protected grounds, there is one set of problem. And the set of problem is what Joe was mentioning earlier, but what people have mentioned earlier, which is the transparency, the access to data, which is, and that is very much of a social issue. But the lack of overlap between the protected characteristic and the algorithmic discrimination, which can even create new forms of emergent structures of discrimination, that is a problem that needs to be understood better and dealt with. And then there are three problems that we've looked into when it comes to indirect discrimination. And the three problems are proof, proportionality, and liability and responsibility. So the first one is the element of proof. What are we looking at? So what elements are we looking at? Which type of information that somebody can bring forward to bring a prima facie discrimination claim? What kind of information are we actually looking into? So if we want to trigger in a prima facie discrimination the burden of the proof onto the defendant, what kind of information are we actually looking at bringing forward? These are all areas that I'm expecting you guys to find an answer to moving forward, by the way. I'm ready to retire soon. Anyway, proportionality. As you know, you have a two-step test where where basically to find whether the practice fulfills a legitimate aim, and whether that means that all the means that have been employed are proportionate to the aim. Yeah? But how are judges going to check that from a technical standpoint? There's not enough knowledge about this. So how are judges going to understand whether the data collected, the systems used, the fairness methodology chosen from a computational standpoint is legitimate and proportionate? And the third is the liability and responsibility. Who, and I forgot the W, who should be held liable for the algorithmic discrimination? I'll come to that in a second, because this is a debate about liability that we're having now. Again, this, and please read this book at the bottom. But the reason why I put this slide is because the debate around liability is quite important. As you know, there are 2 pieces of legislation about liability at the moment in the EU. And one updates the product liability directive for defective products, and the other one introduces procedures for fault-based liability for AI-related damages through the ALD. Now, the ALD, as far as I understand, the latest is parked in the process. Now, the scope of the PLD is to include all AI systems and all AI-enabled goods, except for sort of open source software, with the usual reason that open source software, we don't want to harm innovation and progress and all of that. So, the liability directive acknowledges that an AI system can become defective based on knowledge acquired or learned post-deployment. So basically extends the existing liability to these situations. So what is interesting is both proposals shift the burden from us to the developer. And this is quite interesting. And this is something that we've been advocating in the Council of Europe a lot, in terms of saying, well, actually, I was even going further, like Frank Pasquale and Angeli in the US, and Giancarlo Angeli in the EU, and saying actually there should be a presumption of unfairness, for example, right? Because the idea that I have is that it's really difficult and impossible if the burden of the proof is on you, as the individual. So it's how you shift the burden of the proof on the developer. That to me is the most important point. So this is a good point happening. However, there are a little bit of limitations, and this is where I would very much like, if possible, Joe, to raise this through your aid to the agency, and you all to put a bit of pressure, because there are limitations with the liability directive. And one is that the disclosure mechanism and the rebuttable presumption in the liability directive only applies to high-risk systems under the AI Act. Now, I want to be clear about the European AI Act, which we should stop recording, but I want to be clear about the for like 2 minutes. No, that's it. I want to be clear about the European AI Act. I am delighted by the fact that we have a European AI Act. It's a very good thing. I am concerned, however, on a number of things. One thing I'm concerned is the exemptions under the high-risk definitions. So we have to be very careful when it comes to that. And this is where I think civic society will have to, and agencies will have to play an important role in monitoring this. So on this liability, that's one risk I see that is only based on that. And then the 2 directives proposals assume that liability can only come because of 2 different sources: defectiveness or fault. Yeah? But fault or defect can also emerge in many other ways. And this is a question that I have for you, And in the sense, the question there for you is, isn't it a little bit limiting to say that defectiveness and fault are the only two ways that through which liability can emerge? Or there are other ways, for fault and defect to come up? I mean, I'm thinking about LLMs, for example. Surely, the evaluation, so fault and defectiveness happening through the eyes of compliance with European AI Act is not enough. Because it's not just a compliance with European AI Act that can make that emerge. So that's the second point that there is sort of a little bit of concern about. And the second one is, the other point is the disclosure of evidence. And this is where there is a conflict between legislation at the moment. So in the existing product liability proposal, the defendant must provide evidence that is both relevant and proportionate to the claimants presented. But the Product Liability Directive and the European AI Act are in conflict because the Liability Directive requires evidence disclosure for all AI systems. And the European AI Act mandates record-keeping obligations only for high-risk AI systems. So this is another element where we are looking into putting a little bit of pressure in aligning on these systems. And what does disclosure look like? What is this disclosure that we're talking about? So this is super limitations from a standpoint. So, just because I feel I don't want to bore you anymore, but okay, so first of all, first thing that we've looked into is sort of AI and socio-technical tools means that no technical solutions will ever be sufficient, okay? So in your work on looking into fairness, yes, it's really important to look into the biases technologies. So for example, one area that I'm looking into with data scientists now in some of the companies work for is we're looking at sort of, we're doing a lot of focusing and training at the moment on preparing good data sets and what it means from a fairness standpoint. And where we need to, how we're going to evaluate this data set, where we need to introduce synthetic data to ensure that data sets are ready and of better use. So these are all solutions that are very important, but ultimately the alignment between different teams and different backgrounds will be of what is the choice and the social political choice that you have around fairness. The other thing that is important is that unless there is an obligation to use AI to promote equality, that is not going to happen by default. And this is the point that we're trying to make with the recommendations with the Council of Europe to go to countries from a sort of human rights and gender equality standpoint. If we say that there has to be an obligation to test for fairness, that there is an obligation to, that's not going to be sufficient. What needs to be in there is that there is an obligation to promote equality, because that goes to the main point, which is to create that social and political requirement to override the inherent bias within any AI system. So we then looked at the fairness definitions and the complexities, and then we looked into the fact that protected categories do not overlap with algorithmic discrimination grounds, and how indirect discrimination is the best way to deal with this. Nevertheless, we looked into the issue of limits of existing legislation and how algorithmic discrimination may create new group and elevate them to new systemic inequalities in our society. And then we looked into the issue of liability and the burden of the proof and the limits. Now, I just wanted to quickly say, all these areas that I've mentioned are all areas that require further research, obviously, from the area of liability, from the area of what disclosure means, from the area of how we interrogate systems for example, how judges can interrogate systems or assess proportionality, and what technical tools we may find to interrogate the systems without disclosing the system, for example, using zero-knowledge proof and other ways. So these are all areas where it's really important to have sort of different backgrounds coming together to understand the different, all the different sides that we have. So I'm hoping to have covered in this, and I just wanted to close with with a thank you, the need for diversity, and also how to reach out to me and keep in touch.
Thanks a lot, Ivana, for this inspiring talk. So time for questions, many.
It's a pleasure.
Hi again. Thank you for this really insightful talk. I have a question, might be a bit provoking because I know that you have extensive work on fairness, but we have so many issues dealing with AI, and you address some of them now, regulating AI and etc. And what if we talk about equity, like the Canada is doing, the United Nations is doing, instead of fairness, when talking about fundamental rights protection, equity in the sense of like thinking of inclusion, social individual empowerment. So just changing the terminology to not create more confusion and when working with AI. Thank you.
I mean, I've been asked this question in the past. I mean, why? You would say that. I mean, would you agree with that? I mean,
Yeah.
to change it.
Yeah, because Canada, for example, sorry.
Canada uses
Canada is using equity, the United Nations use equity, and of course there are differences in the terminology.
Yeah.
And fairness, like we have papers and works of saying like fairness is a complicated topic because people understand them differently. And then what if we just change it and then use something that people have a common understanding, so then we can start from a common ground and then work in dealing with other issues than just chasing our own tail on finding, okay, let's find a common definition of fairness and then jump for the big issues.
Yeah, I mean, I don't think that the problem is that fairness is complicated. I mean, the fact that fairness is complicated is actually, in this case, is actually a good thing. I mean, in the sense that it requires us to navigate difficult grounds, especially in relation to how we bring together a computational, mathematical fairness, statistical, with sort of what lawyers, human rights advocate would. But the problem, I don't think, is the change of the terminology. I think is actually how we navigate this, nevertheless.
Is it a social political choice that
Yeah.
we should make?
Yeah, I think so. I think so. Joe, do you think, I mean, I've been asked about this equity, but I'm not, yeah.
Well, I mean, if you're talking about equity, equality, non-discrimination, I mean, it means different things to different people in different languages. So I don't think it's necessarily one model fits all.
Yeah, exactly.
And it depends on the discipline you're coming from, really. So I wouldn't be so fundamental in saying, you scrap one term and replace it with another. And things evolve over time. But in law, things are very slow to change, so there are certain terms that they will consistently use.
Thank you.
Thanks a lot for your engaging presentation. So I have a question, because you're in your role as a privacy officer for Wipro. So like, what are the intermittent self-regulatory mechanisms at place to ensure transparency within your organization? And secondly, you mentioned something about like black box, and then that muddles up the transparency and fairness thing, and it recreates bias. So like, what are the checks and balances that you think could mitigate that?
Yeah. So, in terms of transparency, is that the first question, right? Yeah. In terms of transparency, look, I mean, here I'm not talking about, I mean, I can talk about sort of the role of Wipro, but I want to say two things. So when it comes to companies these days, and just to be frank and open about this, when it comes to companies these days, apart from Microsoft and the big ones, that have their own LLMs, okay? The majority of companies, for the majority of companies using AI will be very much about contract management. Okay? Which means basically they will purchase a license from OpenAI, from Google to Bard or whatever it is, or open source AI, and they will be putting it into their organizational boundaries, using RAG or whatever, augmented the system, and work within it, within the company. For a lot of companies, whatever comes from these big tech and OpenAI and ChatGPT, that's what they will be using. So when you say about transparency, the transparency to me will be the transparency that these companies will provide. And that's why we have to look at what's going to happen in the court case with the New York Times versus OpenAI, because that will be a deal maker or deal breaker. If New York Times wins, I don't think OpenAI will be able to continue the way it continues, okay? And it also depends on the systemic risk AI risk that of the European AI Act. Because one thing I wanted to specify about the European AI Act, the high risk, the 3 levels, it says 4, but in reality we're talking about 3 risk levels of AI, prohibited, high, and then medium liability, so limited risks. They only apply to non-generative AI. Right? They apply to machine learning, automated decision making, based on 3 different. But when it comes to generative AI in Europe, don't forget, there was a huge battle on whether to regulate generative AI or not. With France, who is from France here? With France, good, because I was going to say something. With France saying, oh, we can't regulate generative AI, because we have Mistral, the company. And then 2 days later, emerging, and Mistral was bankrolled by Microsoft in all the newspapers, so nothing private. And the way that generative AI is regulated in the European AI Act is basically by saying there are 2 levels: systemic risks and non-systemic risks. At the moment, the systemic risk is based on the computational power. Systemic risk, it's got obligations of transparency, copyright, I mean, they all have obligations of copyright law and all of this. But what I'm trying to say is that when we talk about transparency of these systems, I can be transparent with my employees in the way that I take one of these systems, I use it, and as you can imagine, I have a responsibility task force, workers in it, and we have a lot of open conversations. But the bottom line remains of these systems and these products that you buy from these big vendors. And the fact that these systems at the moment, they're not providing transparency around where the data is coming from, how they're built. I mean, the interview that OpenAI CTO, Mina Murati, gave a couple of days ago on television, you could Google it if you want, but she basically said we're losing licensed data, but she doesn't know, wasn't able to tell where the data was coming from. And funnily enough, I just read an amazing paper coming from Apple, very specific about where the data is coming from. So a traditional, more closed company was choosing on LLMs to be more open. But so the reason why, I took that element of your question is we've got to be careful when we use the word transparency. Because transparency about what? Yeah? And then obviously, the transparency has to match the person that you're talking to. Because, for example, when it comes to an algorithmic sort of decision-making system used in a high-risk context, for example, healthcare, or used in performance analysis in a workplace, obviously the transparency has to be meaningful to the employee, or has to be to the patient, to the doctor that has to explain the decision if it's a hospital setting. So it has to be work for them. So I actually think that the topic of transparency is probably the most complex one in this area.
Thank you very much for this amazing presentation this morning. My name is Duke, I work at SURF, and the company I work for, we are also participating in developing a large language model.
Okay.
So a lot of these questions, of course, play a large role for us. And one of the things we are thinking a lot about is the bias element that is very present in current language models. And your point about the debiasing practically being impossible, I think very much resonates, because it is practically impossible. But then for us, the challenge is still very much how then do you do it well? So this part of making that socio-technical choice in developing your model, where does that lie, and what does a good large language model look like? I would be very curious to hear.
So you just go look at Gemini and don't do what they do. Although Gemini, everybody took the sort of made fun of them. Do you remember? Because you were asking, can I see an image of the polyp, and there was a black polyp. Obviously, we never had a black polyp. But Gemini did the right thing. They tried. Okay. So I don't have an answer for you. The only answer I have is that you find a way and then you tell me. Because that is what we're trying to understand. So look at how Gemini did it. They actually, I mean, Gemini were attacked so much, and obviously, you know, people like me who work in this sector are always attacked for being too liberal, right? Because we say, oh, because we wanted to do this, but in reality, these people at Gemini, they tried to find a way, again, to fix mathematically, and computation is something that cannot be fixed computationally. But to be fair to them, they really tried. And what came up was a little bit too much. So I would actually try and look at what they did, a little bit more in details. I would actually try and see if there is ways to develop a more participatory approach to this and involve different people from different backgrounds. And then also, I think there is an argument around sort of testing and involving many people into this process. But yeah, but I don't think there is an easy solution to this. I mean,
No, there isn't.
but I got your number, right?
Thank you very much. First of all, I would like to say I work at the local, at the Dutch Data Protection Agency, so I'm really happy. So I'm really happy with how happy you are with GDPR.
It's probably just you and me.
I hope it's true for the rest of you as well. But my question is, because you also work for a big IT company, and I was wondering what can we as the regulators, how can we help you and make stuff, well, easier, I would say. I mean, I can't change the law, I don't have the authority for it, luckily. But the question is, do you need more guidance, do you need more, or do we already have enough guidance out there, and is it just finding the right one?
No, I think you do a good job. I mean, the Dutch regulator is great. So I'm really, really pleased. I'm actually pleased that you're here. Thank you. I think what is really, really important is is to have these multidisciplinary places where, you know, for example, bring together consumers' perspective, non-discrimination and human rights agencies and privacy, and really looking into the issue of fairness from a multidisciplinary standpoint. Because to the issue of algorithmic fairness in particular, if there is any way that the Dutch regulator could initiate a discussion specifically on algorithmic fairness and what it means, bringing together different counterparts, I'm sure we could all, you know, because we would benefit from that, just like on algorithmic fairness, which is very different from sort of traditional non-discrimination stuff. So this kind of bringing together different perspectives, that would be really useful. And then obviously any sort of all sandboxes that we could come up with. But I know the Dutch regulator is really good. So, and there was a question there.
Hi, yes. So I really ate this up. This was very nice. Thank you very much for the great presentation. It resonates as much with me as a mathematician, also working a lot with policy. So yeah, we're in the same jurisdiction. And I know you have been raising more questions than answers, so I understand that there will be another problem added to the list, but I just wanted to think out loud on this one. It's like, I've been thinking a lot about how you need to, in order to say like, we are equally treating everyone across racial groups, you need to know everyone's racial group. And so in order to even make a start at trying to get fair, which actually we know is really difficult to achieve, in that process we really largely violate people's privacy. And also, can a company still allow an opt-out for a person that wants, for instance, not to disclose their skin color? And will we also just bucket everyone in, like, you are Latino, you are black, you are white, and you know, so I understand that it's probably another question to the list, but I also wonder just how does that sort of, maybe for your underbelly feeling, like, is the AI ethics course of action, could that potentially backfire really hard on human rights?
Well, this is a wonderful question. I mean, if only we had somebody from a regulator on data privacy in this room, yeah? To answer the question. I mean, that's correct. You're right. The issue is obviously that if you are a financial institution, you're not new to this problem. Yeah? I mean, the reason why I get a little bit frustrated sometimes when people say, oh, we have to look at fairness. Well, actually, this is nothing new. Yeah? In banking, right, the need not to, for example, the support people with their equal opportunities has always been, it's been there increasingly. The issue around exclusion and inclusion in financial systems, in our financial system, has always been there. I mean, all the banks have done a lot of stuff on that already, and they've often done that with regulators. If I think about the UK, for example, the FCA and the Information Commissioner in the UK, so the Financial Conductor Authorities and the Information Commissioner, they have done a lot of work which would be good to, I'm sure that the Dutch regulator has done as well, on the relationship between these areas. And again, these are all open questions that we need to look at. So I'll give you an example. If I have to give out mortgages, and if I say that I want to be treat in the same way two people coming from two different backgrounds, yes, of course, that may be fair on surface. But if that person coming from a specific background is traditionally part of a segment of the population, which because of institutionalized and racism that we have in this world, is more likely to lose their job, then if I give them the same access to credit, I'm not giving any help. I'm just perpetuating the inequalities that I have out there. So these are things that are hard to navigate, but this is where the cooperation between different areas are very important, including from human rights. Because also you are correct, you know, if you put anyone in a bucket and say this person is black, white, Muslim, yeah, that is also problematic. But this is where a more participatory approach to me is essential. Because we need to look, in the end, you're looking at who is at risk of being harmed. So when you have regulators, for example, from a financial standpoint, and then you have human rights standpoint, and then you have data privacy standpoint, because all of these come together, the eyes that you're looking at this with are who is likely to get harmed? Well, what is the impact? What is the ultimate thing that we're trying to avoid in here? But you know, these are the tough questions that we need to answer. Yeah.
Hi, good morning. Thank you very much for your presentation. I have a very quick question. You pointed out right at the beginning that it's a political choice to promote equality, fairness, whatever word we want to use. I wanted to ask you, isn't it important to point out that it's anyhow a political choice to use AI as it is because it's promoting discrimination? So we have two political choices. It's not just neutral to use the AI we are having right now. So we have political choices going on. So it depends on what side you want to be. You want to be on promoting fairness, or you want to be on the side of promoting discrimination? That's a question that companies, governments need to answer. So I think it's important both sides of the political equation. It's not just a political choice on equality, it's a political choice on discrimination.
One of the reasons why I believe that privacy practitioners are very well placed at taking on AI governance responsibilities in businesses, I mean, I do both, is because I don't take a risk-based approach. In a sense, of course, there is a lot of AI, a lot of risk-based approach in data privacy, obviously. But my first question is, should I do this or not? It's not, I do it and then I manage the risks. My first question is always, is AI the right choice in this to solve this problem? It may not be. This is why one limit of the European AI Act that we have to be very mindful of. Look, in Europe we have the European AI Act. I'm very happy that we are the first ones to have it. In India there is fantastic work being done, if you want I can share with you on AI, responsible AI, and very different from Europe but very interesting. In America they have a different way. We'll see what will emerge. But what is interesting in my view is that a risk approach is risky because assumes that we're doing it. And then it focuses on risk mitigation. But the issue is before that. As you say, is AI the right solution to solve this problem? Well, it may not be necessarily. And I always say this, even with my work hat on, because we are surrounded by glamour around AI. We're surrounded. The AI seems to be solving everything in the world, even the sort of Israel and even everything. Palestine, you know, everything. It seems AI is going to solve the problem in the world. Well, no, it's not. You know, is what is going to solve the problem in the world is the choices that we make. So the reason why it's really important to make this consideration, is my view, is that there is a choice every time to be made around whether AI is the best solution to tackle this particular problem. And this comes before deciding whether we're going to use that system or not. So, yes, there is a political choice around it, for sure.
So we have to close the session. I think that we have a lot of insights that we can bring on from Joe and from Ivana as well. Ivana, do you want to make a final remark?
No. I mean, I would very, because of the work that you're doing, which is very important, and because of how sort of new this is, I would very much like to remain in touch, right? Absolutely. And to find a way to keep us updated on what we are investigating, researching, and that would be really
Thanks a lot, and thanks for being here.